and welcome. Today we will face a peculiar moment in the process linked to the succession, that of the opening of the succession. The opening of succession is a phenomenon from which many consequences derive that deeply influence the whole process of the evolution of the hereditary axis, and which therefore deserves to be examined carefully. Even today, in order not to make the speech excessively technical or intricate, we will only address the main aspects and we will use a simple and discursive language. Let's see a clip together.
The succession opens at the time of the death of the decuyus. It is to say, the person whose inheritance is being dealt. The time when the succession opens is important, as it will, under many respects, affects who the heirs will be, and which will be the share of the decuyus estate that each heir will be entitled to. For example, if the decuyus has died after the separation with his or her spouse, but before they get divorced, then the surviving spouse, even if separated with the decuyus, has, in general terms, the same inheritance rights that the law would have recognized to the spouse before the separation intervened.
Differently, if the death of the decuyus happens after the divorce, the surviving spouse loses all and any inheritance right over the estate of the ex-spouse.
Furthermore, such date constitutes the moment from which a wide set of time limits, connected to the many performances and fulfillments related to the succession, start to run.
In this video, it is our aim to keep things simple, so we are not going to deal with the complex field of the deadlines and time limits associated with the successions.
Even so, it is particularly important to keep in mind two fundamental time limits, exceeding which might lead to severe consequences for the heirs.
First, who is titled to inheritance shall accept it within 10 years from the opening of the succession. If the heir fails to do so, all the relevant inheritance rights will consequently be prescribed and lost for him or her.
A second term, that shall not be forgotten, is the 12 months prescribed time limit to file the declaration of estate. Also, this prescribed period runs from the opening of the succession. Exceeding such time limits might lead to penalties and fines.
Another aspect, connected with the opening of the succession, that is particularly important, is where, according to the Italian law, it opens.
In fact, several bureaucratic fulfillments and performances that the succession procedures require to carry out shall be accomplished before the competent public bodies, having jurisdiction over the place of opening of the succession.
Pursuant to Article 456 of the Italian Civil Code, the place of the opening of the succession is where the decuyus had his or her last domicile.
The time and place of the opening of the succession are of great importance for the Italian law. Some aspects related to these elements often acquire great importance. We have already seen in the episode on testamentary succession that there is a particular category of heirs entail, those entitled to a reserved portion of the estate, who cannot be deprived of certain shares of inheritance, the so-called reserved share. The determination in practice of the amount of this share must be made on the basis of the value of the estate at the time of the opening of the succession, that is to say, at the time of the death of the decuyus. The moment of this quantification becomes particularly important when the testator has disposed of the disposable part of the estate, and the estate itself is composed of assets whose value is subject to fluctuation, such as shares or other securities. The 10-year deadline for accepting the inheritance begins to run from the opening of the succession as well. Often, when one of those having title to the inheritance does not immediately express his will or her will to accept or refuse it, a difficult situation of uncertainty is created, which makes it very difficult for the other heirs to manage and divide the estate, and to any creditors of the decuyus to know from whom to claim what it is due. To solve this type of problem, Article 481 of the Civil Code recognizes the right to anyone who has interested in it to obtain from a judge the setting of a term within which the appointed heir must declare, under penalty of loss of the inheritance, if he or she accepts the bequest. Finally, it is good here to begin to mention a matter that we will better deal with when we will talk about rights in rem. With the death of the decuyus, any usufruct rights that the same might have had on certain properties are also extinguished. Consequently, following his or her death, whoever had already been the holder of the bare ownership rights in such goods becomes full owner. Also today, we have concluded our episode. Thank you again for joining us. Next Monday, we will examine what is the procedure that the heirs must follow to actually take possession of the hereditary estate. We await you. Thanks again for your attention and arrivederci.